All right, guys. So, book club, we are reading Supreme Inequality by Adam Cohen, The 50-Year Battle for More Unjust America. We are going to be talking about how the Supreme Court decisions of the late 20th century and early 21st century impacted the rights of corporations, expanded their rights, gave them more power over things like class action lawsuits and punitive payments. And we're going to be talking about all that in depth. Mm-hmm. And we're going to begin our story in 2008. That arose out of an Exxon oil spill in 1989. So what happened there?
I don't know.
Oh, you don't know?
I kind of know.
Oh, damn. I didn't mean to put you on the spot like that, man. I'm sorry.
You're good.
Right.
I kind of know, but not enough to give like the full context of the story.
Okay. So I can do a quick spark notes.
Yeah.
We got lots of damage to Alaska fishermen because of this oil spill. The captain of the ship was found to be drunk and had a long history of being an addicted alcoholic. A 1994 jury found Exxon totally responsible for putting him behind the wheel. And with this, 10,000 fishermen's livelihood was directly affected because of the damage it did to their fishing waters. So Exxon was forced to pay around $500 million for damage payments, okay, for just regular damages.
Compensatory damages.
What is it called?
Compensatory damages.
That's perfect. Okay, So there's compensatory damages. That's number one. Then there was also a $5 billion amount charged for punitive damages that was, a way higher amount than the damages. And that's what the important dynamic to look at here is. The damage, what is it called?
Compensatory.
Compensatory damages was $500 million. And then the punitive damages was $5 billion.
So the point of punitive damages is pretty much to punish companies. It's supposed to be like, you did a really bad thing, and even if it only caused $500 million in actual economic damages, we are doing this to teach you and every other company a lesson of how much we care about you not doing something that's this harmful, negligent, and bad for the little guy, basically.
It's a tool of deterrence.
Yeah.
It's a deterrence tool, right? It's like, it's like spanking your sibling in front of your kid. It's like, because you know what's going to happen to you. Not saying that I would spank my kids. I don't know why I use that analogy, but it's just, it is what it is. So Exxon was not okay with this. They appealed it to a judge. The judge brought it down to $2.5 billion, but even that wasn't enough. They took this case all the way up to the Supreme Court, and in 2008, the Supreme Court said that they did not have to pay the punitive damages, as it broke the due process clause. Now, what do they mean by that? When they're saying it broke the due process clause, Exxon is arguing that we didn't know how much the fee or the fine was actually going to be for this. And because I didn't know what the punishment was, you can't drop a big punishment on me, and I didn't even know what it was going to be.
Yeah.
Which, isn't the worst argument. I think that's actually a fine argument. I think people should know the consequences of bad actions.
Except that there had been long-standing precedent that punitive damages would be used like this deterring factor.
Yes.
And that it's hard to say that there can be a specific amount, because this is one of those where it really is such a case-by-case basis of like, how bad of a thing did the company do?
Yes. So with that punitive damage decision, there were many people who were confused why Exxon would even cite the punitive damages part, because this clause has nothing to do with corporations. It only has things to do with individuals. The law doesn't mention corporations. The due process clause comes out of the 14th Amendment, which was a Reconstruction Amendment meant to make black people more equal to whites in America. This had nothing to do with corporations' right for punitive damage claims. How are these two things being tied together? It's part of a long game. It's part of a long game.
Exactly.
They're laying the seeds. They're doing what Justice Powell told the U.S. Secretary of Commerce or Chamber of Commerce to do all those years ago.
Yeah.
That we talked about if you're an OG on this show, So now we're going to rewind.
Yeah. Well, it was part of this conservative movement where the business class saw punitive damages as a really huge cost that was hitting the bottom line, right? And so the Exxon case was an example, but there were other ones that had came before the Exxon case ended up being decided that were leading up to this cap.
Yes, and there's a whole movement in the 1970s talking about tort reform. So what's tort? I had no idea what tort was, to be honest with you. Torts is a negligent or intentional action that causes harm, which could be anything from a defective product to fraud. So tort reform advocates were saying that there was an over amount of litigation to these types of cases, with runaway juries posing enormous punitive damages that were not fair. And they wanted this reformed so that punitive damage either could be more outlined exactly what they would be, or just lowered, period.
Yeah.
Or I don't know what they were thinking, but eliminated. And this is when the term like frivolous lawsuit kind of became popular. And the good example is that old woman who spilt McDonald's coffee on herself. And everyone was like, she spilt hot coffee on herself and she became a millionaire. Please go back and actually understand what that case is about. She was served coffee that was so hot, it burned her skin to such a degree she had to get skin grafts.
Yeah.
This is not a frivolous lawsuit.
No, she was literally inhibited from like fully moving for years.
She was disabled.
Yeah.
And then these guys pushing for tort reform framed it as this frivolous lawsuit. It's unbelievable, man.
Yeah.
And so what they were pushing for was punitive damage caps. And at this time, they weren't popular with the Democratic establishment, so nothing was being passed on the federal level. During this time period, the Democrats controlled the House for a very, very long time. So nothing about this was going to be getting through. But now the court, it's a different story.
They had the power.
They had all the power.
Yeah.
Conservatives were in there. So now we get to 1996. And so this is the first case we're going to be talking about.
BMW of North America v. Gore.
That's the one.
Yeah. So this one I can't explain.
Good.
So Dr. Ira Gore, he was sold a car under false pretenses. So this car from BMW had suffered damage from acid rain, I think.
Yeah, that's right.
And so its surface and its paint coat had been damaged, and BMW decided to just slap a new coat of paint on it and sell it to him anyways without ever saying anything about it. The compensatory damages were probably about $4,000. I think it was $4,000.
It's around there, yeah.
But the court awarded him $4 million in punitive damages because it said BMW's policy constitutes gross, oppressive, or malicious fraud. Because they hid it.
Exactly.
They weren't upfront about it. That was the issue.
And it was also baked into their policy. Their policy was if the damages wasn't more than 3% of the price of the item, then they would just forget about it.
Exactly. So it was revised to $2 million in punitive damages on appeal, and then it went to the Supreme Court, who ruled 5-4 that the $2 million was excessive and it violated due process.
There we go. What's important to know at this time is it's not totally ideological yet. There are still some liberals who voted in favor, and there are some conservatives who voted against. So this isn't a total ideological fall yet.
Well, as far as I know, it stays mixed.
No, it doesn't. It ends up being hard line.
Really?
Yes, it ends up being hard line.
Okay.
Yeah, when it gets to the later
end?
years. Yeah.
Okay.
When it gets to the later years.
Okay. Yeah, for years it's mixed because there are liberals who like the idea of more specific defined punishments.
Yeah, what I just said, you should really, honestly, you should know what the punishment is for your crime.
Yeah.
That's only fair. That makes sense. I agree with that on principle. I get that. But as we'll get into, it's not the court's place to decide the punishment. It's not what the court is supposed to do. That's what the legislature is supposed to do. If they're not doing it, then they're not doing it. So in 2003, we have another case like this. State Farm is encouraging a client to go to court to fight an insurance battle for an accident. And State Farm is so confident in this case. They're like, look, go fight it. If you lose, we will pay all your lawyer fees. We'll literally cover the entire cost. There's no risk for you. So he's like, okay. So instead of having to pay the $50,000, he had to pay $185,000 after he lost. State Farm was wrong. And then State Farm was like, screw you, man. We're not paying you the money. You shouldn't have trusted us. Why'd you do that? You're an idiot. And so this guy, Campbell, this guy had Parkinson's disease. He was caught in State Farm's strategy to limit payouts. Like the goal here was they were targeting people specifically for this.
Literally, it was like, let's prey on the weak because they're not gonna know their rights and be able to sue us to actually get us to pay what we agreed we would pay.
This is the policy of a massive corporation. This is their goal. This
Yeah.
is literally what they're going to do. They're telling you right now.
Yeah, it's like in writing.
Like, unbelievable. So Campbell won the case against State Farm and was given $1 million in compensatory damages, and $145 in punitive damages. I mean, that's what you love to see.
Yeah. Like with this kind of thing, again, it seems like that's the size of a slap on the wrist that you should be going for.
Yeah, when you're literally having it in your books.
Yeah.
Preying on the weak.
Yeah. But the court said this was too much, and this is a big step because the court put a specific number on how much more should punitive damages be able to be than the compensatory.
Yes.
And they suggested that punitive damages should be less than 10 times compensatory damages.
Yes.
Which
so
again,
a ratio of 1 to 1 to 9.
Yeah. Goes back to what you were saying about this is clear judicial lawmaking.
This is just lawmaking.
Yeah.
There's no ifs, ands, or buts about it. This is just lawmaking. Literally, there's nothing about punitive damages in any law, or not any law, but nothing that the legislature has passed is regulating punitive damages.
No.
Why is the court regulating punitive damages? What is happening?
It makes no sense.
And so we're limiting the amount of punitive damages for less than 10, right? So Ginsburg said the court was, in her dissent, she said the court was changing the law on punitive damages very quickly in favor of corporate defendants. She said that juries were trying to send a message against companies like State Farm. And this is the term, weakest of the herd. That was their term.
Yeah.
That's what it was. Quoted, weakest of the herd. What a bunch of assholes. What is wrong with them? What is wrong with them? And then
it's just like it's cinematic.
It's like an Austin Powers villain. It's so funny.
It's ridiculous how evil it is.
It's like the bad guy's name being Dr. Evil. Right?
Yeah.
Like that's like what the corporations of America are like, unironically.
Yeah.
So then there's another massive case with Philip Morris. Philip Morris is the big cigarette company. They were like big battles in the 90s and 2000s for cigarette regulation. So in 2007, an Oregon jury ordered Philip Morris to pay widow of Jesse Williams $821,000 in compensatory damages and $80 million in punitive. Oregon Supreme Court was disgusted that the company knew about the terrible effects of tobacco but continued to lie to the consumers over the years. Mm-hmm. So this is an example of punitive damages being a strong deterrent factor.
Yeah.
They're going up to Philip Morris and they're saying, listen, you lied to your consumers. We're going to show that if you lie to your consumers, to anyone else, if anyone else lies to their consumers, they're going to be hit with a hammer is going to come down on them.
Yeah.
So Philip Morris v. Williams, it was ruled 5. So they appealed all the way up to the Supreme Court. Philip Morris won 5-4. With, again, liberals and conservatives on both sides. It's not ideological yet, which this one shocked me. Like, the fight against the cigarette companies was very ideological.
Yeah. Yeah. Well, it shocked me because the rationale and the decision felt super shaky. Like, it felt really unconvicted to me. And what they said was that they expected that Philip Morris, and I think it was Stevens wrote this, or it might have been Breyer. It was one of the liberal justices, that they worried that Philip Morris was being punished for plaintiffs not represented in the case.
That's kind of the point.
Yeah.
That's kind of the point.
Exactly.
Yeah. Like, it's supposed to, like, I think Breyer's taking issue with the fact that the compensation is not just for the person suing, but the whole point of punitive damages is to be a larger social outlook and painting a social picture of what the companies should be allowed to do. And it's like he's taking issue with that whole concept. Mm-hmm. So when this comes out, the New York Times was disgusted by the ruling, and there was a Harvard Law article in the Harvard Law Review that said they had turned the 14th Amendment into a tool of the rich and powerful when it was supposed to be a tool for the least of these. Great quote.
Yeah.
And I totally think that the 14th Amendment has just been totally co-opted.
Yeah.
Especially after reading about these cases, just totally co-opted. Unbelievable.
Absolutely. I actually had a call with my mom today, who was a public defense attorney for her whole career, and we were talking about like the affirmative action case recently, which also co-opted the 14th Amendment. Just in the idea of spirit of the law versus letter of the law, and she said, yeah, I'm definitely on the side of spirit of the law. And the more we learn about these cases, the more that I'm firmly on that side as well, and that I would assume that should be like taught in law schools. Like that should be the basic assumption, right? You're interpreting based on what they meant by the law, and you're trying to apply that to the specific case that you're reading. So the idea that it's a problem, that they're trying to make a larger societal statement here with the punitive damages, makes so little sense, because that is the spirit of punitive damages. That is the
spirit of the law.
Yeah.
That is the spirit of punitive damages, exactly.
Yeah.
That's what their goal is. So we see this again, we see this ratio come up, the punitive to compensatory damages ratio come up in that Exxon case that we were talking about before.
Mm-hmm.
And what blew my mind, literally blew my mind, I couldn't believe this when I was reading this, during that Exxon case, the court just decided that the ratio is at least is like 1 to less than 10 times, right? They just decided that. Well, now during this Exxon case, they decide, well, you know what? This has to do with maritime law, and since that was more complicated, the ratio should be 1 to 1. They just changed the ratio.
Yeah.
But why? You just made it. You literally just made up a law. You literally just made it up.
Yeah.
Saying that it should be at no more than 10 times. And now you're saying it's no more than 1 time?
Which you're also making up on grounds, on a rationale that has absolutely no connection.
What does maritime law have to do with any of this?
Yeah, why would that change how much the punitive damages should be?
Why? So Ginsburg said if there were to be a ratio on punitive damages, it should come from Congress and Congress alone, not made up by the court. Exactly.
Yeah.
And the idea that they were just so willingly able to change the ratio after making the ratio themselves, it's just disgusting. I don't understand. No, like someone explain to me.
And I don't understand how the liberal justices talked. I mean, we talked about where their mindset came from, but punitive damages are purely a punishment to corporations, to massive corporations, right? That it is a balancing of the little guy, the David with Goliath.
That is the whole point of punitive damages.
Yeah, and that's the whole point of the liberal ideology. So like, where are these justices? What are they thinking?
I don't understand. Well, so this is what they say in the book, right? This is the next part here. They say some liberals like the idea of capping punitive amounts on the belief that people should know what their punishments for a crime would be if they committed it. Mm-hmm. Yes, but this is the court, like you just said, taking away the broad power of punitive costs as an idea of deterrence. Mm-hmm. And it's not coming from Congress. I don't know why they got off on this. I'll never understand why this happened. And I don't understand why there isn't a legislative push to remove the cap imposed by the court. Like, reading through this book, it's really outlined to me, if I were to get into federal office, the exact things that I would push for. I would go back and I would try to remediate all of these cases through law. Through making new legislation. Yeah. That's what I would do right away. I would say, you know what, we're going to get rid of the punitive damage cap set by this case. We're going to go back and we're going to take away the McKay doctrine when we're talking about rights to organize and union labor. Like, I would go back and rectify all of these terrible decisions day one. Yeah. That's what I would do.
It's funny because I think it would be tough, or at least with this specifically, right? Because say you enact that law, it goes to the Supreme Court. And you get a conservative court. Mm-hmm. Aren't they just going to say this violates the 14th Amendment?
Well, hopefully statute should overwrite some of a made-up algorithm imposed by the court. I pray that statute overrides a fake algorithm made by the court.
You'd hope so. The problem, this is the huge problem with the court, though, because their precedent is law. Right. And so now there's all of this evidence that's already in the books that says this is what the 14th Amendment means. Mm-hmm. And they have all of this to support their cases. Because I feel the same way as you.
But look at Lilly. Oh, wait. I have issues with this, actually. Because this is an interpretation of a constitutional amendment. But the Lilly Ledbetter case was not. It was using statute and it was arguing about a specific aspect of the Civil Rights Act, which was made by Congress, not the Constitution. So if you use constitutionality in a Supreme Court decision, you can't statute your way out of it.
Yeah.
You can only statute your way out of it if the Supreme Court decision was in issues with statute. Damn, that sucks. That sucks. So that's just the way it is?
Unless we get another amendment.
What a nightmare. Are you fucking serious?
Yeah. Well, I mean, this could lead into a whole conversation.
Yeah, this is a whole other conversation.
Yeah.
But maybe you pass this during a liberal court and then it passes. But that's what we have to do in this country? What a nightmare. What a joke.
Yeah.
All right. So I want to rewind for all the OGs. We have, you might remember footnote 4. Footnote 4 was discussing what types of laws should need to have strong scrutiny.
Special scrutiny.
Special scrutiny.
Yes.
And they described in footnote 4 that discrete and insular minorities deserve special protection under the Equal Protection Clause. Well, the modern court has determined that wealthy corporations deserve special protections from jurors' possible biases against big corporations. That is, what's crazy to me is that the footnote 4 isn't being used in the spirit of footnote 4 isn't being used to protect the poor, protect the disabled. It's being used to protect corporations about the fears that juries are so anti-big business that they're going to drop such high punitive damage costs on them just because they hate them. So corporations are a discrete and insular minority. You know what I mean?
Yeah, that's insane.
Insanity.
Yeah. To try to fit that square peg into that round hole, that corporations could be an insular minority. That's wild to me.
Unbelievable. So that's when we're talking about punitive damages. We're going to switch gears a bit, I think, right? Mm-hmm. Is the next case switching gears?
Yeah. I mean, if anything, we can talk about how I think there was a part of the book that it kind of rested here to discuss how pro-business the court has become.
Yes, you're right.
So there was a study on how many, or on what percentage of Supreme Court decisions went in favor of businesses. From each court, starting with the Warren Court to the Berger Court to the Rehnquist Court to the Roberts Court. And each court got more pro-business. It was from 28% of corporate won cases during the Warren Court up to 64% of rulings being pro-business in the Roberts Court, which is wild. Another study found, or it was rating which justices were the most pro-business since 1946, and it found Sam Alito to be the most pro-business justice and John Roberts to be the second most pro-business justice.
See, and that's why I hate Alito the most, right there. Yeah. There's the evidence.
Sure.
That's it. That's why I think he's the worst.
Yeah.
So we're just getting more and more conservative justices. We're getting more and more further on the right of the court. Businesses are winning cases more often than regular people. Yeah. And it's just it's a removal of what the court had the opportunity to be. Right? Yeah. The court had under the Warren Court, they set a chart. They charted a course that really looked like the court could be the slingshot that David used to take down Goliath.
Yep.
You know,
that was the point of it.
That was
supposedly.
Right. Supposedly.
Right. I mean, I don't know.
We've already talked about how it's not.
Yeah.
But, you know, it
supposedly when it was founded.
Right.
I mean, like, it seems like that. It is the justice system.
It's like the general idea of what the court is. That's what you think about it as.
Yeah. Right. I mean, that's what I think about it as.
That's what I thought about it as.
It seems crazy that it would be an enforcement mechanism of the powerful.
Right.
Which is what it has become.
Right. So, unbelievable.
Yeah.
The next part is something I really am interested in. The class action lawsuits. There's a whole movement against class action lawsuits. So class action lawsuits made it possible for large numbers of employees, consumers, to band together and file a single lawsuit together. Why would you want to do this? It's because many poor and middle-income people could never sue on their own because the cost is too high. So if you band together, it's way more likely that you'll win, and it's way more likely you'll have the resources to keep the fight going.
Yeah.
And I love the idea of them. I love the idea of a bunch of people who have been wronged by a company coming together and trying to take it down together.
Definitely. It also works for cases that are going to give smaller rewards, because you're never going to sue for one person who's been robbed of $10 or $15 or $20. But if 1 million people have, then you do want to recoup those damages from a company.
Definitely. And some of the cases we've talked about previously, I didn't know, but were class action. So one of them was King v. Smith. That was a class action one. And the other one was Rodriguez v. San Antonio Independent School District was class action. That was a really big case because that was the one that was talking about equalizing school funding.
Okay.
Yes, and that was class action.
Yes, I do remember that now.
Yes, that was class action.
And also we talked about the Walmart one. I think this was last week.
Yes, we did.
Right, where Walmart, or the court said that the women who were bringing the Walmart case didn't suffer a similar enough injury to bring it as a class action. And that's one of the biggest cases in the history of the court to limit class actions, right? Like the narrowness that they required out of the injury that was imposed on the plaintiffs, that discouraged so many more class action lawsuits from ever taking place in the future.
It was cited 1,200 times in the first year alone, and it was very frequently cited to overturn jury decisions. So that Walmart case was rampantly popular across the country. Just unbelievable. In 2005, so prior to the Walmart case, Congress actually did do reform for class actions in the sense of doing like tort reform. They were on the side of trying to limit these frivolous class action lawsuits. And Congress enacted the Class Action Fairness Act and made it easier to move class actions from state to federal courts. Federal courts would be much more likely to be conservatively appointed at the time. Okay. So Ed Markey, who's a senator from Massachusetts, was highly against it and called it what it was, a payback for the big industries that owned America. Yeah, Ed Markey's a great senator.
Yeah, he is.
Yeah.
The other case that I have here is Caroline Barrand,
yeah,
who was prevented from suing Comcast because members of the class would be entitled to different damages. This one's crazy. So if you start with the Walmart case saying that the plaintiffs didn't suffer a similar enough injury, now it's like there's different amounts that they should get from the case, and that means they can't sue together. Think of the logical extreme of this. You can think about literally cents of difference. That means that they can't take it a class action. So for Comcast, something that's doing cell service, right, that could be about the number of texts that a person sends. Like, right. What if they went 2 texts over the limit versus 10 texts over the limit? Now they can't be part of the same class? I
don't understand.
That's ridiculous.
I don't understand. They said that people across states were all dealt harm in a different way. How?
Yeah, I don't know.
Explain to me how, please. For the love of God, somebody explain to me how. After this case, a very popular headline was spread around, the end of class action. And that's so depressing. Class action, views, to me, I already said this, the sling that David used to take down Goliath. And I can't think of a better way for regular people to fight back against the powerful than a class action suit.
Exactly. Like we're just seeing the tools of the poor, of the underprivileged, of the weak being stripped away like one by one. Right? I mean, I feel like that's what this book is. It's just seeing all of those taken.
Yeah. And this one, it doesn't look like they're using constitutionality to justify these decisions. So this could be changed by law.
Yes.
Right?
I think so.
So that's good to know. Everyone who's in Congress who watches us. Okay.
Yeah. All of you.
Yeah, all of you.
Yeah.
all the congressmen who watches. Forced arbitration. That is our next topic.
Yeah.
Okay, so corporations in many of their contracts to consumers and employees make you sign away your right to court. Yeah, you have to do forced arbitration within the company to figure out any problems that you may have.
Yeah, like when you're on your phone and you download an app or go to a website and you have to check a box for terms and conditions, it's probably in there.
Probably in those terms and conditions, right. You have like a 50% shot. This was actually a liberal idea in the beginning.
Yeah.
which is so interesting to me. Frank Sanders, a big proponent of the idea. He was a liberal lawyer, and he liked replacing the one-size-fits-all policy of which was court litigation with a modern one that was tuned to each specific type of dispute. He liked that concept.
I get that.
Yeah.
I get that because it is so costly to go to court.
Exactly.
So I was just talking about the progressive push or the liberal push for arbitration as an alternative to court cases because of the flexibility and hopefully because you could go through arbitration at a much lower cost.
Right. Now, the issue with this, because it sounds great, the issue with this is when cases are brought to arbitration, it's not by juries or judges that make these decisions. They're arbitrators that are appointed and bought by the corporations. So the arbitrators actually have a very, very strong incentive to rule in favor of the corporation that hired them.
Yeah.
There's one Harvard law professor, Elizabeth Bartholet, and she experienced firsthand that she was siding with customers on a lot of cases, and then she was removed from all the cases in the future because the corporation decided that they didn't want to hire her anymore. They thought she was a bad arbitrator, and arbitrators can cost $10,000 a day and make over $1 million a year. So why would somebody go and be a public judge when you only make $200,000 when you could 5x your money?
Yeah, and it's so easy. Like, you don't actually have to worry about the case. You just rule in the company's favor every time.
Yeah.
It's honestly, it is like the picture of corruption. It is quintessential corruption.
And it's encouraged corruption. And 94% of the time, these arbitrations are cited on the business.
Yeah.
94% of the time. So this isn't, what justice is being served here if you're just going in and voting with the corporation every single time you have to arbitrate a dispute? It's ridiculous.
It's literally just a waste of your time.
It's absolutely ridiculous. So in 1991, there was a question now expanding to employees. And 1991, could employees be forced to arbitrate legal disputes, including discrimination cases with their employer? Robert Gilmer wanted to bring a case about age discrimination, but the company he worked for said that he could not, as he was forced to arbitrate within the company.
Mm-hmm.
This is such a break from the Civil Rights Act. It's unbelievable.
Yeah.
It's like, why even pass the Civil Rights Act if you're going to have forced arbitration?
It's the court just being like, oh, we don't have to worry about this anymore.
So the court ruled against Gilmer, 7-2, said that they had to abide by the standards.
7-2.
7-2. So the liberals were in on this.
Yeah.
The majority cited the Federal Arbitration Act. But what's so interesting about the Federal Arbitration Act is that the word employee doesn't appear once. The act was specifically supposed to apply to two sophisticated businessmen. Where is the word employee in that? Where's the word employee there? Where's
I don't hear it.
Yeah, I don't hear it either. Where is this coming from? And so that's a real decimation to worker rights.
Yeah, I mean, and the cases that go back to the Arbitration Act afterwards just kind of strengthen it more and more.
Right. They just keep citing the same part.
Yeah. So there was an Amex case where there was a restaurant that said Amex had scammed it. I don't remember exactly what
they were just using their monopoly power to charge fees that were too high.
Yes, that's right. And so this Italian Colors restaurant wanted to go to court because the arbitration in this case would actually cost more than the damages amounted to.
Mm-hmm.
But the court ruled that they had to go to arbitration, again, relying on this Arbitration Act. The one other that I have here is Jacob Lewis v. Epic Systems, who looked to go to class action arbitration. And this was in 2018, I think. And Neil Gorsuch said that the Federal Arbitration Act required the arbitration to be enforced. And this was kind of the nail in the coffin, in my opinion.
Well, this one's crazy because Lewis is specifically citing Section 7 of the National Labor Relations Act, which guarantees workers the right to work together to protect their interests. Mm-hmm. So now corporations have figured out a way to kill collective bargaining in the United States. I feel like this wasn't talked about enough to be as big of a deal as it is. This is the end of collective bargaining, period.
Yeah.
This is the end of unionization. This is the end of forming new unions if you sign these forced arbitration agreements.
Yeah.
So don't sign them, please.
We say that, but then like
Then you're forced to because you need a job.
And again, half of companies at least have them in their contracts.
Mm-hmm.
And this is what I was thinking about when I read this is like, man, once a norm is established, right? And companies see that they can do this and not really lose any of their competitiveness as far as signing on new employees. Of course they're going to.
Of course.
And it's just another sign. Again, we talked about worker power a lot when we read Stiglitz. This is annihilating worker power, just evaporating it.
No, evaporating it. Then he talks a little bit about environmental protections. In 2009 in Alaska, a company pumped toxic wastewater into a lake. Just pumped toxic wastewater into a lake. The Army Corps of Engineers gave it a permit. EPA never did. The corporation was permitted to drop enough toxic waste that it would have eliminated all life in the lake from the Army Corps of Engineers.
Wow.
And the people suing this were not allowed to come together in class action. So there was no way for them to individually win this case.
Mm.
And due to these different arbitration issues, there was just no way to sue and get the EPA the power that it deserved in this case. So this is just a direct attack against the EPA's, like you're putting the Army Corps engineer permits over the EPA permits.
Mm.
Yeah. I don't know. I have two more cases here, and then
Oh, really? Okay.
no, I have two more. One of them is about antitrust. So with antitrust, there's something called the Essential Facilities Doctrine, and the Essential Facilities Doctrine helps had the potential to help rein in large tech companies because it prevents companies from abusing their monopoly over a service or product that a different competitor needs. That's a super important aspect, but they totally eviscerated that doctrine, and the court was taking away the main legal doctrine for taking so-called bottleneck monopolies. That you want to be able, if a company has a monopoly over one input in a very big system process, and they're able to exploit their market power to hold on to that input and keep it from getting into other hands that might actually compete with different companies within that larger corporation, you're causing a bottleneck in the overall general economy that should be avoided, but you're artificially creating it to boost your profit margin.
I see.
And the court is giving them the right to do that. And by this point, I just want to give some updates on how class actions have fallen. So class action settlements fell from 2.7 billion to 1.3 billion just from 2017 to 2018.
Yeah.
It's just 1 year, and it's a whole $1.5 billion less.
And it was from it was from the Lewis v. Epic Systems case.
Yes, that's the one that did it.
Yeah.
That's the one that did it. And now, by 2018, 54% of workers are affected by mandatory arbitration. In 1992, it was 2%.
Yeah. And of course, the natural conclusion to draw is that all of these companies are going to include mandatory arbitration.
Why wouldn't
clauses.
they? They'd be stupid to not.
And so 81 out of the top 100 Fortune companies have mandatory arbitration clauses in their sales contracts. 78 of 100 have class action waivers in their sales contracts.
What a nightmare, guys. This is such a nightmare. All of us watching need to get elected so we can try to undo as much as we can of this, because this is crazy.
It really, like to see how little power you now have as a citizen. And this is supposed to be the whole foundational idea of democracy, right? Is that you can band together and make your voice heard because of the strength in your numbers, and they're just wiping that out.
Totally wiping it out. Now it's all about the size of your wallet, right?
Yeah.
And that's the world that they want to live in. And we need to get out there and fight for a different world and different vision, because this is nuts. This is nuts. I don't care if you're a Republican or a Democrat. This is nuts.
Yeah.
I do not believe that a Republican from Wisconsin who is voting for Donald Trump because he didn't like the way NAFTA was negotiated. I do not believe that guy thinks that class action lawsuits should be should be able to be completely avoided by corporations. I don't believe that to be the case. I do not think. I think there's a massive majority of American citizens that would love to see changes to this type of stuff. They just don't know about it.
Exactly. Yeah. So hopefully they're listening.
Hopefully, eventually, because we will be listened to by every American at some point.
Yeah.